So I now hand on to the Chief Justice Sundaresh Menon.
Thank you. Thank you very much, John. Chief Justices and judges, friends, welcome to the first roundtable discussion of this meeting. And the topic, in line with what I said in my opening remarks, is technology in a new world. In 2018, when we first discussed the need to confront the issues that were going to be presented by the impact of technology on every aspect of society, inevitably including the courts, we sensed that we were already in a new world, one defined by what has been described as the fourth industrial revolution. Where the earlier revolutions had been marked by the shift from a reliance on new forms of energy and then the breakthrough to new and widespread electricity distribution, to the emergence of new forms of digitization for the storage, processing, and sharing of data and communications, this latest revolution is one marked by wholly new ways in which technology is becoming embedded in our societies and affecting our lives and our activities. Examples include things like artificial intelligence, the blockchain, cryptocurrency, genome editing, and a host of other things. And the pace of change is simply astounding, with seemingly new technologies becoming overtaken and even pushed into extinction, sometimes before they have even been properly appreciated. For us as judges, typically schooled in the humanities and often accustomed to having others adjust to our way of doing things, the rapid growth of technology and its infusion into our professional work and lives can be unsettling. But whatever our personal feelings may be, the phenomenon is already well underway. From having electronic filing of documents to having to access, review, and work on documents in soft copy, to holding hearings by Zoom, to having to deal with the legal issues presented by electronic discovery, contracts concluded by computerized algorithms, and accidents involving autonomous vehicles, there is no doubt that technology is upon us and that the speed and extent of these changes will only accelerate. To guide us through some of this, we have put on the website a very helpful pre-recorded segment by Professor Maxi Scherer on the use of AI in the specific context of predicting legal outcomes and outlining the capabilities and limitations of the existing models. I'm aware that the organizers have asked that we watch this in advance of today's discussion, but for those of us who might not have had the time to do so, I strongly encourage you to view it because it presents a good overview of some of the issues. But for today's session, we will begin with a pair of opening speakers. First, Sir Jeffrey Voss, to whom I must first extend my heartiest congratulations on his recent appointment as the Master of the Rolls and Head of Civil Justice in England and Wales. Sir Geoffrey will lead us with an opening address that touches on the opportunities presented by technology and its interface with the justice system, and also on the question of the data generated by the system. Whose is it and what can we do with it? The Chief Justice of Brazil, Chief Justice Luiz Fuz, was originally scheduled to be the other speaker, but I understand that he is unable to be with us today, and his speech will be delivered by his colleague, Judge Scherer, Secretary General of the National Council of Justice of Brazil. And it will outline the Chief Justice's thoughts on how we should see technology as an enabler, the potential use of artificial intelligence in the justice system, and in particular in adjudication, and the concerns and issues that the use of AI might give rise to. Thereafter, I will take questions and contributions from the floor. Please use the function at the bottom of your screen to raise a hand if you wish to intervene so that I can call on you, and then there will be the need to unmute yourself when I allow that. In addition, within the time that we have, I will call on 4 other delegates to add their contributions on some specific issues. I also ask that you have your video on, especially if you wish to make a contribution to the discussion so that you can be seen by all the other delegates. And then finally, Justice Nageshwara Rao of the Supreme Court of India will make some closing remarks before we bring the session to a close. It is my hope that in the course of the next hour or so, we can explore and hopefully flesh out some of the ways in which technology can help us, while at the same time being alive to some of its potential limitations, difficulties, and issues. It is now my pleasure to call on Sir Jeffrey Voss. Sir Geoffrey. You need to ask to unmute yourself.
I hope I've succeeded.
You have. Thank you.
Very, very good. Let me then start by thanking Sundaresh for the very kind introduction, and I'll be as brief as I possibly can. Municipal justice systems in general and commercial courts in particular, I think, need urgently to acquire a better understanding of the disputes that they will actually be required to resolve in the new technological era. The debate this morning should be less about how we can do digitally what we used to do using analog methods, and more, I think, about understanding how technology will fundamentally affect the disputes themselves. Most jurisdictions internationally have done well to undertake remote hearings during the pandemic, and even to move away from paper towards an entirely digital environment. But none of that is using new technologies, nor is it changing either the way we resolve disputes or the kinds of dispute we are resolving. And these two things must now be our focus. I will start with the kinds of dispute that will need resolving in the future. We are on the verge, I think, of a digital revolution in commercial life. It will not be long before almost all business will be undertaken by the use of electronic documentation, electronic signatures, smart legal contracts, and on-chain records. Immutable digital records will abrogate the need for courts to resolve many of the factual disputes which we're accustomed to at the moment. Electronic documentation is particularly significant, as it will liberate the transfer of property at all levels from its remaining documentary boundaries. But the UNCITRAL model law on electronic transferable records was concluded back in 2017 and has thus far only been enacted in Bahrain, Singapore, and Abu Dhabi, and by the latter two jurisdictions only in 2021. There have been a number of impediments to the inevitable, eventual, and ubiquitous use of on-chain smart contracts. The first impediment was the lack of a clear understanding of the legal status of crypto assets and smart contracts, something that the UK Jurisdiction Task Force took forward in respect of English law with its legal statement on the subject at the end of 2019. The second impediment is the absence of dependable central bank digital currencies, or CBDCs, to allow smart contracts to execute automatically. Several central banks have trialed CBDCs, and some may be about to launch them. But there's no CBDC currently in which international business can have real confidence. The third impediment is the absence thus far of a universally accepted method of digitizing commercial and legal documentation. That problem is highly soluble, but the options available are not at the moment uniform. And the fourth impediment is the absence of a universal dispute resolution process for smart contracts and crypto assets on chain. The UK Jurisdiction Task Force will, however, shortly publish a set of digital dispute resolution rules, providing for arbitral or expert dispute resolution in extremely short periods, providing for arbitrators or experts to implement decisions directly on-chain using a private key, uniquely, I think, and providing for the optional anonymity of the parties. Now, once these four impediments are overcome, as in my view they surely will be, commercial courts and arbitral tribunals will be resolving an increasing volume of on-chain and electronic documentation disputes. Trading on the financial and insurance markets, trading in physical and intellectual property, and the documentation of transportation is all likely to be undertaken electronically. Lawyers, judges, and arbitrators will need quickly to acquire a comprehensive understanding of how these technologies work. Let me now turn to the way in which we resolve disputes. Our justice and trial systems are very much based on a 19th century model, even if the hearings can now be undertaken remotely. In an era in which everything can be delivered with 2 or 3 clicks on a smartphone, I do not think that international business people will accept the cost and delay caused by our current approach. But as yet, very little thought has gone into the fundamental reforms that are necessary. In the UK, we're moving towards an holistic online environment for most civil disputes. And I see no reason why the model cannot be rolled out to the resolution of larger commercial cases. Online dispute resolution has a number of advantages. It allows for a single transferable data set to be created for each case. It allows for asynchronous interactions between the court on the one hand and the parties, witnesses, experts, and their lawyers on the other. It allows also for integrated ADR interventions at all stages of the dispute in place of a single staged mediation, which may or may not be effective. It should also speed up the process considerably. Finally, an online dispute resolution process will allow for the considered and appropriate use of artificial intelligence to aid the dispute resolution process. AI can be used to analyze and make sense of increasingly large data sets. It can assist in bringing about mediated solutions, and it can distill the relevant legal precedents. We do not, I think, need to fear the use of algorithmic technologies that are already present in almost every other aspect of our lives, although we do, of course, need to ensure that we understand what the algorithms are doing to prevent bias and unfairness. So to conclude, I've tried to give a very rapid tour d'horizon around what commercial disputes and commercial dispute resolution might look like in a very few years from now. What it shows, I think, is that lawyers and judges will need to demonstrate flexibility and be prepared to learn new skills. The business communities that our justice systems exist to serve will not forgive us if we refuse to adapt to ensure that we can resolve the disputes that arise in a new streamlined technological environment in an equally streamlined and adept technological manner. In short, the days of lengthy paper pleadings and bundles are numbered. On a personal note, I can say that I now operate without using any paper at all, and I have found that one can determine even the most complex cases without it. Truly, Sundaresh, it is a liberation. Thank you.
Thank you so much. Thank you so much, Geoffrey, for that brilliant overview of some of the issues that we should be thinking about. Let me turn to Judge Scherer to present his remarks, please. Judge Scherer.
Good morning, good afternoon, good evening, dear members of this roundtable. As a Secretary General of the Brazilian National Council of Justice, I will speak on behalf of Justice SIFoCC, President of the Brazilian Supreme Court. It's a great pleasure to attend the third meeting of the Standing International Forum of Commercial Courts. Events such as this one are extremely important as we have the chance to gather and discuss with judges from different countries and cultures about the evolution of the judicial branch, especially in the digital era. Since the first day Justice SIFoCC assumed the presidency of the Supreme Court of Brazil and of the National Council of Justice, he considered the promotion of technological innovation as one of the structural guidelines of his 2-year term. We are focused in Brazil on delivering a high-quality judicial service, which should be closer to the citizen and align with the demands of an increasingly connected, dynamic, and global society. We aim at a broad, unrestricted, real-time digital access to justice for all Brazilians while expanding governance, transparency, and efficiency. The technological revolution that is taking place in the Brazilian judiciary branch has not only allowed the continuity of the judicial activity during the pandemic, but also increased judges' productivity. Our experience has reinforced the idea of justice as a service. The Brazilian judiciary branch already has digital systems for court procedures since the early 2000s. However, their existence did not dismiss personal and live attendance of the parties, witnesses, and lawyers to hearings and other acts. Although important, the digitalization of the judicial process was not enough for the judicial system modernization. We needed a true transformation in the working methods and procedures, going beyond its simple incorporation into existing processes. In the path towards this transformation, the National Council of Justice approved last October a rule stating that local courts must offer rooms prepared for video conference to be used in procedural acts, especially statements of parties, witnesses, and other collaborators. It also established a program called 100% Digital Court, which is already being used in 20 courts around Brazil. This program allows citizens to take advantage of technology in order to access justice without the need to physically attend the courts. All procedural acts being performed electronically and remotely through internet. The digital counter was added to other tools available in courts, such as phone calls, emails, messaging, and apps, simulating services that would be provided in local and reducing costs. The National Council of Justice has also improved the security of the digital systems, creating the Cybersecurity Committee of the Judiciary Branch. Technological innovations will enable a remarkable transformation of the judicial performance. We have almost 80 million lawsuits in progress in Brazil, which correspond to one lawsuit for every 2.72 inhabitants. This represents almost 7,000 cases for each judge in Brazil, resulting in one of the highest workloads in the world and consequently in a high rate of congestion. If the use of technological resource was already proving to be the best alternative to deal with the great amount of litigation in Brazil, that practice was definitely consolidated with the advent of the pandemic and ensured the continuity of the judicial services. The question everyone is asking now in Brazil is, what will life be like after the pandemic is over? The global mobilization will not only have implications for the way we organize our healthcare system, it will also shape the way we structure our future economics, politics, culture, and consequently, the judiciary itself, which brings me to the final point of my presentation, artificial intelligence. AI systems have several benefits to the practice of law, especially in relation to the automation of repetitive activities by providing quickness and precision in their execution. AI tools can be used for several purposes: advanced call search, online dispute resolution, predictive analysis of decisions, process screening, grouping by similarity of case law, voice transcription, control of procedural management, among others. The Brazilian Supreme Court itself can be considered as a good example of the use of artificial intelligence in the judiciary branch. In partnership with 3 faculties at the University of Brasilia, law, software engineering, and computer science, the Supreme Court is developing a project called Victor. This project and this tool makes us use of machine learning and already performs at least 4 activities in the court. It converts images into text in the digital process, separates and classifies the most used procedural files, and most importantly, identifies the precedents to be potentially applicable to the case to be judged. The advancement of AI in our judicial system will also benefit from the recently launched Judiciary Branch digital platform, whose main objective is to modernize the electronic judicial process and transform it into a multi-service system, allowing courts across the country to adapt it to their needs while guaranteeing the convergence of the automatized procedures in Brazil. It's worth noting that the National Council of Justice has established criteria for the production and use of artificial intelligence in Brazilian judiciary. Such criteria seek to preserve equality, non-discrimination, diversity, transparency, and auditing through the adoption of good practices and recognized governance standards. The process data are subject to specific protection in accordance with the General Law of Data Protection, approved in 2018 by our National Congress. This entire scenario expresses a new reality for the Brazilian justice. We call it Judiciary 4.0. The use of the vast possibilities that technology can offer in order to achieve notable cost and time reductions with a significant increase in efficiency. I would like to add that the systems that make up the Judiciary Branch digital platform are public and available not only to Brazilian courts, but to the entire international community. The National Council of Justice is at your disposal for the exchange of experiences so that we can collaborate to pave a successful path in favor of the judicial system efficiency. Finally, allow me to congratulate the Standing International Forum of Commercial Courts and especially Chief Justice Sundaresh Menon for the organization of this third meeting. Thank you very much on behalf of Justice SIFoCC, Chief Justice of the Brazilian Supreme Court and of the National Council of Justice. Thank you.
Thank you very much, Judge Scherer. Thank you so much for those remarks and for giving us an overview of how you've approached the issues in Brazil. Let me very quickly see if there are any contributions from the floor. And maybe whilst we are waiting, I will invite Mr. Chris Campbell Holt, who is the Registrar of the Astana International Financial Court, to give us a brief intervention on technology in the administration of courts in the new world. Chris?
Thank you very much, Chief Justice Menon. May I check that you can hear me clearly before I start?
Yes, indeed. Yes, indeed.
Thank you, Chief Justice. May I start by thanking you, Chief Justice, to all of to our hosts and all of the SIFoCC team organisers for this meeting. For anyone who doesn't know or is not aware of the AIFC Court, we are a new common law principled international commercial court based at a new international financial centre called the AIFC in Kazakhstan. We're the first of our kind in the whole of Central Asia, and we are, for anyone who's not aware, similar in some ways to more developed, more experienced courts perhaps based in Qatar and in Dubai and Abu Dhabi. In terms of the court technology, we have, before COVID-19, set ourselves up to be 100% online. Parties can, if approved by judges or if judges decide it's appropriate in a given case, have hearings in person. But of course, during the COVID-19 pandemic, that has not been possible. Many of the investors investing into this part of the world are not physically located or able to travel to our premises, indeed not even to Kazakhstan. We've provided all of our dispute resolution online. We developed and launched in 2019 an e-justice system. I'm aware that some of the SIFoCC member courts already have a similar system in place, but I'm also aware that others perhaps do not. I hope that what I have to say will prove to be of value to those SIFoCC members. E-justice essentially is an electronic database for documents and all case management before and during trials. We also use video technology for pre-trial and trial hearings. This has been ongoing, and we've resolved more than 400 cases during the COVID-19 pandemic across the court and our sister connected arbitration centre. The key advantages that we have identified, and there are many that we would consider to be enablers of the technology that we use, are fourfold. That is time saving. Documents are now transferred through secure connection with no need to wait on a courier or physically visit a court. Our system immediately updates when new documents are filed. Parties may go through each document back to back at the touch of a button without having to sift through voluminous papers. Second, better use of resources. Our system eliminates the need to print out documents. We are largely paperless, enabling parties to make last-minute edits to documents without printing out enormous quantities of paper. Our e-storage is automatic, it's secure, and it reduces paper storage need. There are significant cost savings as a matter of everyday practicality for lawyers and parties to disputes at our court. We estimate those to be in the region of about 80%. And this is compared to the physical document filing that perhaps would have been used before COVID-19. There are, of course, significant transportation cost savings and the like. Thirdly, increased accessibility. Parties may examine important documents simultaneously wherever the parties are located, with 24 access if needed. We have worked very hard to develop 24/7 technical support, and this has proven to be very important, not because of the failings of the system, but of course with all IT systems there are from time to time some technical issues which require expert assistance from a qualified team. Fourthly, improved connection to information and more control. With reading on a screen, text searchability allows parties to exercise greater control over information. Critically, we found in practice, documents are filed as soon as parties click submit. This is time recorded to prove parties have met the deadline with absolute precision to the second. So far, we believe that this technology has held up to the challenges that we've put in front of it. One of the key challenges when implementing such new technology in a court, especially for us in Kazakhstan, which previously did not have such technology, is to really inform, to make fully aware and train the whole legal community. We rolled out a significant campaign, if you like, of promotions and also technical training of the legal community to ensure that everyone had an equal opportunity to have access to justice to our facility. That's all I wanted to say at a high level in the time that I have. Thank you very much, Chief Justice Menon.
Thank you very much, Chris. Can I see if there are any hands raised, any questions, any comments? If not, Geoffrey, I wonder whether I might ask you to comment on a point that you covered in your remarks. You made, I thought, if I may say so, an extremely important and valuable point, which is that the whole focus on technology has got to shift away from this idea that we continue to do the things we used to do, but using technology. I mean, we used to have hearings, we just do it through a computer or a video conferencing platform. I think that was an extremely valuable point. The two things I wanted your comments on, particularly because I think you're a shining and inspiring example of how this can be done. How do we train judges who are already in the seat to come round to embracing technology and acquiring the necessary know-how to be able to do it? And then the second point, which is a subset of that, is what should we be focusing on in terms of the content of training? Because I think it goes beyond learning how to use the tools to actually understanding what the technology is doing, what it is capable of doing, and what it is in fact doing. Because if you don't have that understanding, there's a lot of wool that can be pulled over your eyes, and there are a lot of things you're going to miss in the process. So I wonder whether you could take those 2 points, Geoffrey.
I think, first of all, the training of judges who are in place already is we have shown easier than we thought. A lot of judges were very reluctant to embrace even video hearings, and certainly to embrace PDF files rather than paper ones. And yet we found that they get used to it, and there's a bit of mumbling and grumbling and a little bit of technological support needed, but actually it can be done. And all judges really are capable of working on screen now. So that's the first thing. But as regards training, I think we do need to consider training for a completely new era. And that was really the first point I was making in my short address. The fact is that we're going to be dealing with quite a different world. You know, we're used to resolving disputes about who said what to who in a meeting. But now everything is technological. People record everything on WhatsApp, on social media. Everything is in writing. There are pictures of everything that ever happens anywhere in the world. And I don't think we'll be resolving the same kind of disputes. And when technology affects documentation, which is why I mentioned all that in my address, that is going to need training for judges to understand how to deal with technological documentation, to understand new rules for transferable documentation in the commercial sphere. And I think that's where we should be focusing. So Sundaresh, my answer is, I think they will quite happily, judges will quite happily get with the program of using remote systems and technological systems and screen-based systems. But as for training, I think that's got to be more fundamental, because we're looking at a different way of doing business in the next 25 years.
And you've shown us what is possible, because I don't see a single piece of paper on your table. I'm most impressed.
And actually, there is a single piece of paper. If there's any papers that people send me, and then I just throw them away.
Can I see if there are any hands raised? If there are any questions from the floor? Yes, please. If I could just ask you to unmute. Yes.
So greetings from Kenya. Can I be heard?
Greetings.
You can hear me?
Yes, I can.
Yes. Thank you so much for the insightful presentations, very informative. Just wanted to ask, how are we all dealing with the technology divide, especially the self-representing litigants, so that we ensure that we have access to justice to all? Because in Kenya, yes, we have the e-filing system, but we are struggling with self-representing litigants. Thank you.
Thank you. So I'll just offer a comment, and then I'll see if anybody else wants to add it. I'm sure that both Jeffrey and Judge Scherer has something to say on this. But I actually think my own view is that I think technology can be a tremendous tool to advance access to justice, because there's lots of things you can do with technology in terms of making information available, in terms of actually getting legal solutions and possible legal packages of information available to the people that they might not otherwise be able to access. Our own experience in Singapore when we started moving towards e-filing was to recognize that there was a possibility of a digital divide, the divide that you speak of. And how we dealt with that when we moved to e-filing was to set up what we call service bureaus, where members of the public could go and file their documents at the service bureaus in the event that they weren't able to access a computer for this purpose. Similarly, during the pandemic, when we effectively had to switch almost on a heel very, very quickly to remote hearings, one of the areas where we were particularly mindful of was in the family justice space, where there is a high degree of representation of individual litigants in person. And in order to ensure that they, who sometimes were the people who most needed access to justice during the difficult circumstances of the pandemic, what we did was we set up Zoom rooms, and Zoom rooms were facilities that were manned, staffed, so that members of the public who couldn't otherwise access a computer, or didn't know how, or didn't have the necessary bandwidth, could actually go and use the Zoom room, and there would be staff on hand to assist them to access justice. This is a problem that will diminish with time. I have no doubt that in 10 years' time, or however long it is, I have no doubt at all that people will feel far more comfortable. There'll be far more people who feel completely comfortable with technology than people who feel lost with it. And so it's a problem, a particular problem, I think, with a limited shelf life, which we will overcome. But in the meantime, whilst it is here, we can't ignore it. And therefore, we have to make these practical intermediating solutions. That would be my contribution. Jeffrey or Judge Scherer, I wonder whether you have anything to add.
I completely agree with everything you've said, Sundaresh. Actually, I think that technology is a tool to create access to justice, not to deny it. Obviously, different states have different take-up of technology and different mobile phone usage and smart device usage and computer availability. And as Sundaresh says, we all must make absolutely sure that we're not creating a technological system without dealing with the vulnerable court users. And we've certainly done that in the UK. And I know that Sundaresh has done the same in Singapore. But having said that, it is extraordinary how many people do have access to smart devices the world over. And we would be, I think, denying access to justice if we didn't move towards technological solutions whilst making sure that we are careful to provide services for the vulnerable.
Thank you, Geoffrey. Judge Scherer, did you want to add anything?
Oh, yes, I would like to also say I completely agree with your remarks and remarks of Your Honorable Justice Jeffrey Voss, and also would like to add that one of our main concerns in Brazil is to make it easier for people who don't have access to internet to have access to justice. For instance, in the Amazon forest, we don't have completely access to internet, so we have to use satellite to provide access to justice for the courts in Amazon region. And for instance, Amazon was very badly affected by the COVID pandemic, so the courts had to close it all for 1 month, and it worked finally just by remote means of due to the technology we have. So I think that's we reach a point of no return, and we must have training for judges so we can see in the future the limits of the technology for justice. That's what I see.
Thank you. Thank you, Judge Scherer. Now, I'm going to take an intervention from Registrar Visser, who I think is from the Netherlands, and then I'm going to break to a pair of contributions for a couple of minutes. But Registrar Visser, let me give you the floor first.
Thank you for giving me the floor. I have one thing to say about e-filing. We, as the Netherlands Commercial Court, were fortunate that at the start of the COVID pandemic, we had an e-filing system in place, so it was very smooth. There's an additional problem maybe with in-person cases is that you have to assess the identity of the person who is filing a document. And the Netherlands Commercial Court only does cases where lawyers need to represent their clients, so we don't have that problem. But I can see for the future that we need to see how we can resolve fixing the identity issue, especially where it concerns foreign individuals. And the second comment I would like to make is on artificial intelligence. I've seen the contribution before on your website. It's very interesting. I can see two forms that we can use AI as judges. For instance, if you want to check what the outcome would be of your case using a database, then artificial intelligence can be very useful. It has also been suggested that it could be a part of the decision-making process. Or maybe even replace the judge. I'm not sure that's the case because a lot of times a human will be involved, has to be involved because of the numerous factors that are important in decision making. However, I do see one option that is in default cases, so where the defendant does not show up in court. There's a lot of judicial guidelines in the Netherlands, for example, to decide on standard cases. Those guidelines could be entered into a computer and applied to case. If there would be a judicial check at the end of such a process, that would be, I think, acceptable for the public, because that's ultimately where we do it for. The decision has to be accepted by the public, acceptable. So those are my comments. Thank you.
Thank you. Thank you, Registrar Visser. And your second comment in particular, I think ties in with 2 points. I want to link it back to something that Judge Scherer said in his remarks, where he talked about the use of artificial intelligence in particular ways. And one of the things he talked about was in the context of the automation of repetitive tasks or tasks that are routine, relatively uncontroversial. And it's exactly in that setting, I think. But that segues to two contributions I want to bring in at this stage. I'd like to invite first the Deputy Chief Judge of the 4th Civil Division of the Supreme People's Court and a judge of the China International Commercial Court, Judge Shen Hongyu, who's going to speak to us briefly on the use of technology as an enabler and the problems that call for solutions that we will find in technology and AI in particular. And immediately after that, I'd like to ask Justice Mark Horner of the High Court of Northern Ireland and judge in charge of their commercial list to address us on developing ethical frameworks for the use of artificial intelligence. So if I could first have Deputy Chief Judge Shen Hongyu of the Supreme People's Court. Please, Judge.
Thank you for giving me the floor, Chief Justice. I would like to introduce the 4 unique features about the use of technology in Chinese courts, especially the technology that ensure users access to the justice. Can you hear me?
The connection is a bit unstable. I'm not sure why. We're losing you at some points. I wonder whether I could ask you to just start again, Judge.
Okay. So I would like to introduce 4 unique features about the use of technology in Chinese courts, especially the technology that ensure users access to justice without interruption during the COVID-19 pandemic. First, the court under your finger. The Supreme People's Court developed China Mobile Phone Micro Court. It's a WeChat app allowing online case filing, getting up-to-date court information, online payment of fees and costs, and online hearing, etc. All matters are on the smartphone, like this one, saving parties from appearing before the court in person. This February, online filing function for cross-border litigants was added to the app, enabling overseas litigants to file the case and entrust attorney. The app already had 3.55 million users. Second, a game changer. The new mediation platform. After 2 years construction of a one-stop diversified dispute resolution platform, more than 165 mediators were incorporated into the platform. The average mediation success rate reaches 65.7%. In 2020, the mediators effectively mediated 4.24 million cases online. It is not only beneficial to the parties for the efficiency and cost effectiveness, but also a far-reaching effect in reducing the court's caseload. We have seen the first decrease of filing in 2020 since year 2004. Third, the special court adapted to the new digital era, the internet courts. There are 3 internet courts created in 2017 and 2018, respectively in Beijing, Hangzhou, and Guangzhou. All of them provide a new full process, online and trial mode with paperless. The average handling time of a case is merely 60 days. And it was mentioned that the Hangzhou Internet Court explored the asynchronous trial mode so that judges and parties can attend a hearing in different time and different places. Fourth, open to the public, enhancing judicial transparency. The Supreme People's Court created 4 online platforms to enhance judicial openness. The China Judgment Online has publicized more than 120 billion judgments and decisions up to now, with 57 billion visits. And the China Court Trial Online have live streamed 11.5 million hearings. And the China Judicial Process Information Online has delivered 2.3 billion pieces of messages to parties, which give users the information and directions of court processes. Chinese courts eagerly look forward to learning technology experience and best practice from other countries, and will continue to enhance application of technology to provide better judicial services and deliver a fair, efficient, and cost-effective justice for all court users. Thank you very much for your time.
Thank you. Thank you very much, Judge Shen. That was very, very interesting. And obviously, I think China's experience with technology, I've personally seen some of the capabilities, and it's really quite remarkable. I'm going to now ask Judge Mark Horner, Justice Mark Horner of the High Court of Northern Ireland, and judge in charge of the commercial list there, to speak to us about developing ethical frameworks on how we should think about the use of AI. Justice Horner.
Thank you, Chief Justice. I'm delighted to participate in today's event, and I'm grateful for the opportunity to contribute to this discussion. Artificial intelligence applications are powerful technologies. The important balance between efficacious use and recognition of risk awareness and potential for misuse must be struck. There has been a concerted effort to provide standards for evaluating the quality of AI applications and their ethical uses. A full regulatory framework which supports the development of AI technologies while considering the ethical aspects of their application has yet to be established in the United Kingdom or throughout the European Union. Meanwhile, the technological development of AI is rapidly progressing in academic circles and increasing its market presence. On the 17th of July 2020, a working group of the EU's European Commission issued a report entitled The Assessment List for Trustworthy Artificial Intelligence. The authors of this report were members of the High-Level Expert Group on AI, an independent group formed by the European Commission. This expert group included representatives of European academic institutions and large technology companies. This publication examined the principles in connection with the implementation of AI. Firstly, ethical purpose and benefit to society. AI systems should respect fundamental human rights and be used only for ethical purposes. Secondly, accountability. AI systems should be subject to human control, and individuals should remain accountable for the acts and omissions of these systems. Thirdly, transparency and explainability. AI systems that interact with the public should be disclosed, and their decision-making process should be transparent. Fourthly, fairness and non-discrimination. AI systems should be fair and non-discriminatory and avoid perpetuating discriminatory social attitudes or data. Fifthly, safety and reliability. AI systems should operate reliably, safely, and ethically. And lastly, open data and fair competition. Since many advanced AI systems require large data sets for their training, appropriate government entities should foster and facilitate open access to the necessary data for all sectors of society. Turning briefly to the first of these principles, Virginia Dignam, in her book, Responsible Artificial Intelligence, How to Develop and Use AI in a Responsible Way, addresses comprehensively the use of ethics in AI systems. She prefers the term responsible AI as opposed to AI ethics, as although the two principles are closely related, she considers that action is required for responsible AI, while ethics can be merely observed. She examines what ethical action is, approaches to ethical reasoning, designing artificial moral agents, implementing ethical deliberation, and the ethical status of AI systems. She categorizes responsibility for the design of ethics in such systems in three areas: ethics in design, ethics by design, and ethics for designers. With the time available for me today, I have merely signposted the issues which are and require to be the subject of thorough debate and consideration. I can put it no higher than has already been wisely noted by the IEE Global Initiative on Ethics of Autonomous and Intelligent Systems. As the use and impact of autonomous and intelligent systems becomes pervasive, we need to establish societal and policy guidelines in order for such systems to remain human-centric, serving humanity's values and ethical principles. Thank you very much for the opportunity to present to this conference.
Thank you very much, Justice Horner. I know Lord Hope has his hand raised, and I'll turn to him in a minute, but I wonder whether I could just raise one question to you, Justice Horner. One of the things you said in terms of developing ethical frameworks was the importance of ensuring that there's transparency. And of course, that goes towards critical issues of due process and being able to understand the decision maker, as well as being able to meaningfully address the decision maker, to persuade the decision maker. One of the difficulties that Professor Maxi Scherer identified in her pre-recorded segment was the fact that most, or many, perhaps not most, many of the prevailing models for predictive AI techniques, and I suspect you could take that even further, don't have necessarily the ability to explain their decisions. They can tell you, they can give you a prediction, they could give you a solution to the problem, but they may not be able to explain how they got there. And I wonder whether that's an inherent limitation in AI that we need to be really conscious of.
Thank you very much. Yes, I agree. I think it is an inherent limitation, and it's one that that we do need to be aware of. But I do think that with the improvement in technology, it's a matter that is going to be resolved in the relatively short term.
Okay, thank you. Lord Hope, you had an intervention. I need to ask you to
Yes, thank you very much, Chief Justice. I have a practical question for Sir Geoffrey, if I may. I'm putting myself in the position of a judge who is being trained. And a practical question I would put is this, based on my own experience: what do you do to provide the judges with the equipment that they need? For example, for home working, which judges have to do from time to time, I find that I have to have 3 screens. I need a screen for typing my judgment, and I use 2 screens for access to the various materials which are before me. There's an investment required here. What do you do, Sir Geoffrey, to provide your judges with the equipment that they actually need to live up to the standards which you very rightly are setting for us all?
Well, you're absolutely right, David. Of course, we do need more equipment than we ever did. And I think in perhaps the what one might call the first world economies, where governments can afford to provide judges with appropriate numbers of amount of hardware, it's probably easier actually in my court, in the Court of Appeal in England and Wales. If judges ask for new screens, they get new screens, including screens for home when we've had COVID restrictions. But I think that's easier said than done in some other countries where resources are much slimmer. I think in reality, I think it's a question of speed of working. I mean, you know, I can talk, and many people call me a bit of a geek, and I'm sitting on my desk here with 6 screens, actually, which, you know, probably is a bit excessive. But I can actually work on a laptop on a single screen, and you can do it. It's just more time consuming. And so I think we shouldn't be completely limited by a lack of resources, but we should obviously try to give judges what they need in order to work efficiently. I think it really is a question of making it more efficient.
Thank you very much indeed. Thank you.
I'm reminded, Geoffrey, of an exchange I had many years ago when I was a young lawyer, and I was typing with 2 fingers, and someone said to me, "You're really good. I need all 10."
Well, that would be training, which we really could start with young training for people to type, because those of us of some age never learned to type and do it with 2 or 3 fingers. And amazingly, we can do it quite quickly, but really we ought to have learned it.
Yes, I very much regret not being younger and having been properly trained in typing. But I do find the new systems very helpful indeed, and my experience is largely based on arbitration. But the use of technology for arbitration, particularly international arbitration, is well advanced, and I find it very easy to live with.
I have a hand raised from Justice Horner. Justice Horner, did you want to intervene?
No, I had no comment to make. Thanks.
Okay, so I'm almost coming to the end of the session. I'm going to invite my colleague, Justice Edith Abdullah from the Supreme Court of Singapore, who's going to give us a couple of his ideas on how we should be preparing for the procedural, evidentiary, and substantive questions that will face commercial courts in the age of technology and commerce. Edith, please.
Thank you, Chief Justice. Good day to everyone. As mentioned by the Master of the Rolls, technology increasingly infuses commercial work. Smart contracts, blockchains, and before too long, AI will be prominent and permanent features of commerce. The challenge for courts from this interweaving of technology and commerce is manifold: case management, evidence, and of course, ruling in the cases. Importantly, the pace of change threatens to overwhelm any individual effort to keep up. The courts must therefore mount an institutional effort requiring lifetime continuing judicial training. This may seem a bit controversial, especially for common law jurisdictions in which traditionally judges in the superior courts arrive on their appointment as finished products with years of accumulated experience and knowledge, and they're supposed to have what it takes to do their work. But relying on pre-existing knowledge is no longer enough. Just as much as lawyers in practice are put through the rigor and pace of continuing legal education, so should judges too undergo continuing judicial education. Induction programs and occasional seminars are not enough either. Having sufficient knowledge and expertise in the interplay between technology and commerce will require a program covering not just a general appreciation of technology, but consideration of its impact on commercial transactions and instruments. This will need to be done over several, if not many, sessions. Furthermore, courses will constantly have to be developed to deal with new areas. Thus, continuing judicial education has to be structured and topical. Training materials would also need to be continually developed. As judges will not have the time to delve deeply into specific areas, the participation of academics who do have both the time and inclination is essential, and bringing the two worlds together to produce primers and courses would be beneficial to both. But I acknowledge sustained continuing programs would not be within the means of all courts, and even those that are able to would not be able to cover or anticipate all possible areas. Topical roundtable discussions on a regular basis among commercial courts can plug this gap so that judges can keep abreast of developments in other jurisdictions and mutual learning can be encouraged. Crucially, all these activities must be supported by robust and extensive knowledge management within the court to ensure that the relevant information is not only captured, but readily available for future reference. Importantly, time must also be given for such training and familiarization. Sparing time for training may seem onerous on already strained calendars, but it is essential for judges and courts and leaders to ensure that such time is given and that it is an accepted part of working life. All these efforts will need to be sustained in order to make a real difference. The permanent appointment of an officer or judge responsible for updating knowledge and training on technology and commerce will be essential to ensure that the objectives are met. But with these efforts, I believe courts can ensure proper preparation for the issues arising out of technology and commerce so that the needs of the users of the court system can be met and justice served. Thank you.
Thank you very much, Edith. Thank you very much, Edith. Just by way of background, Edith is actually the judge in charge of transformation, innovation, and technology in my court. And one of his big assignments, one of his big tasks is to think about how we can make justice as accessible as possible to the average citizen, the average resident in Singapore, how to make it as accessible as possible using technology. So it's really been occupying his mind, and thank you for those observations. We're coming nearly to the end, and I want to call on Justice Nageshwara Rao to close in a minute. But just before we do that, I wanted to raise 2 points, just pulling together a couple of threads from the various points and interventions that we've had, and also thinking about this and perhaps asking, again, Geoffrey or Judge Schenkena to comment on these points, or anyone else. The first is, I think we've talked about, David talked about it, Geoffrey talked about it, Edith talked about it. We really need to be rethinking the whole question of training and education. But I want to suggest that this has to go much deeper. It's not just at the point of training judges, we should be thinking about radically transforming the curriculum in universities, because the lawyer of the future, who will also become the judge of the future, I suspect, the lawyer of the future is going to need a whole array of different types of skills. And that's an issue that I think needs to be carefully thought about. How are we thinking about the future of legal training? And related to that, I think the future shape of the legal profession is going to be very different, because I think that the legal profession of the future is no longer going to be exclusively made up of LLBs or lawyers. We're going to have a lot of different types of skills, like technologists and coders and computer scientists with an interest in law, or logistics managers, all kinds of different skill sets and capabilities. So we really should be thinking about how we make sure that we have a throughput of people with the requisite skills coming through, and that in turn gives rise to questions on how we regulate some of those issues. I don't think we have time to address these points, but I think they're very important points that we should be keeping at the back of our minds. And then the second big issue that I wanted to comment on was what I call the complexification of disputes and issues. I think technology has fed or turbocharged our tendency to make things ever more complex, because we can gather more data, we can organize more data. I think Judge Schenkena talked about how we use AI to organize data, to do searches, to collate data. All of that means that lawyers are able to use technology to amass massive amounts of data, which complexifies the disputes. The problem is all of this has got to be dealt with at the back end when it comes to the adjudicators. And we're presented with disputes that are ever more factually complex, with ever more heavy loads of evidence to deal with. And I spoke about this at a lecture I gave last year, where in an arbitration, admittedly a factually complex arbitration, evidently the submissions, without the exhibits, the submissions came to 10,000 pages. And if you allowed a few minutes to read and understand each page, I did the calculation. I think an arbitrator would have had to do nothing else for the best part of a year or for 8 months or something, just to read through that stuff. And then that assumes that the person's got a photographic memory to be able to process and hold all of that material. So we need to be thinking about how we address the downstream consequences of all of this data that is being presented to us and that is coming before us. So those were two issues, big issues, that I think we need to have at the back of our mind. Jeffrey, you've got your hand up, and I'm going to give you the floor before I turn to Justice Rao.
Just 2 quick points on your 2 quick points. Sundaresh, can I just say on complexification, I think this is the biggest nightmare affecting all judges. I think it's necessary for commercial court judges to be absolutely rigorous about restricting the length of submissions, restricting reference to authority, and requiring lawyers to do what they should have been trained to do, which is to focus only on the real issues in dispute. And technology should help us do that, not hinder us. There is much data, but there's very often a very small issue in dispute. And judges have to be quite strong in telling lawyers to focus on what that dispute really is. And as regards training, I completely agree. I've myself been saying the same thing for some time, but I don't think judges are going to have to be computer coders. I don't think they're going to have to be technologists, but they're going to have to understand the language, they're going to have to understand the concepts, and they're going to have to understand, as I said earlier, the way business is done in the modern world, and that will require different kind of training.
Thank you. Justice Rao, the floor is yours.
Thank you, Chief Justice Menon, for the opportunity to be part of this very interesting discussion today. Technology becomes significant in addressing existing challenges impeding the legal system in multidimensional ways. To make a meaningful impact in the continuously evolving legal framework of a developing nation, due importance has to be given to the remaining constituent elements of this composite machinery, who are the citizens. One of the focal points of onboarding technology in the legal domain is to resolve the bottlenecks faced by litigants in their access to justice. The onerous pressure created on the judicial system, with a significant number of cases remaining pending at various levels, creates a domino effect in terms of excessive delays, which can undermine respect for the rule of law. Several policy initiatives of the Indian government, supplemented with various research and academic pursuits, have recognized data, communication, infrastructure, and algorithms as key enablers for the purposes of implementation and innovation. National Judicial Data Grid, an offshoot of the Mission Mode project, has been implemented as a monitoring tool to identify and manage pendency of cases by keeping track of more than 30 million cases at various levels in the Indian judiciary. In addition, certain algorithmic tools are being currently tested to assist in translation of judgments in English into vernacular languages and vice versa, as well as for looking into motor accident claims, which are typically adjudged by weighing various relevant factors to the factual matrices of the cases. The use of such tools will be tremendous assets to the justice delivery system by improving upon the efficiency and productivity of the system. With digitization of processes around administrative functions, legal services available to litigants will be more streamlined, cost-effective, and time-bound. By eliminating repetitive activities requiring physical intervention, judicial proceedings can be accelerated. Additionally, the e-courts project, implemented with the eventual aim of automating processes, will provide transparency and access to information to all relevant stakeholders. This will go a long way in retaining the trust of the people in the reach, accessibility, and efficacy of the judicial system. The role of a judge is complex, involving various facets of activism, educational and social commentary, case management, as well as adjudicatory functions. There are several factors which impact decision-making, including intuition and the capacity to assess social impact of decisions. Accordingly, at least in the initial stages, the overall approach should be to allow technological processes and tools to bring in continuous improvement in decision-making and creating a judiciary that is in step with the technological developments in the 21st century. Thank you.
Thank you. Thank you so much, Justice Rao. Thank you very, very much. That actually brings us to the end of this session. I know it feels like it's not enough, and really, in truth, it isn't enough, because there's so much that there is to talk about and so much that there is to think about. But we have to do what we can within the time limits that we have. I want to bring the session to a close really by, first of all, thanking Jeffrey Voss and Judge Scherer for the very, very helpful contributions that we started the session with, and for their responses to many of the comments and the points that were canvassed in the course of the discussion. I also want to thank each of the four contributors, Judge Shen, Chris Campbell-Holt, Justice Horner, and Justice Adit, for the effort and thought that they put into their respective pieces. I also want to thank Justice Rao for his closing remarks. And I want to thank each of you for having made your contributions, your comments from the floor. I'm sorry that we don't have more time, but I'm sure this is a subject that will warmly respond to even more discussion in the future occasions when we meet. So with that, let me turn the floor back to Lord Thomas and say thank you very much to all of you again. John.
That was a fascinating discussion. It shows one of the foods for thought we're going to have to discuss is how we take this forward, whether we concentrate more on the nuts and bolts of getting it to work, or what we do about ethics and AI. And finally, to Jeffrey Voss's Brave New World, not of 6 screens, but of all commercial transactions essentially being done in digital format. But now we have a break, as I understand the way our system works, and we begin again at the time that's illustrated on the program. It's at various different times. So we have a slight break now, and then we get together pretty shortly because we did overrun slightly. So I think people can remain logged in, and then we start again, if you look at your program, at the time that is advertised in it. For those who are enjoying a good evening, or should I say a good night, that next session will be, I think, tomorrow morning. For those of us who are in the morning or in the afternoon or evening, we will continue in about 3/4 of an hour.